Hello, everyone, and welcome to this Sunday episode of In Lay Terms. I'm your host, Payman Ascari. I have back with us a recurring guest and my personal friend, Mr. Trevor Holsworth. Trevor, welcome back.
Hey, Payman. Thanks again for putting me on your show there on this short notice.
No, anytime. You've been more than gracious when I've asked you to come on, so I'm happy to accommodate. Today is going to be a very easy episode for me. I'm going to hand it over. I'm going to put on my sunglasses and pretend to be awake, and you're going to steer this ship. So tell us what's going on.
Right. So, this decision on October 31st there about the Centerville case about the child abuse issue is sort of it tracks into my case absolutely, and it tracks the whole story almost. So the judge that I experienced, who declared that that judges could protect lawyers committing fraud, he was involved in this case, R versus Sharpe, which was debated in Parliament as to the fitness of this man as a judge, because he declared the law on possession of child pornography back in 1999 to be unconstitutional, the entire law. And so that made it, And police chiefs, same event. Everyone was completely upset across Canada. It was outrageous. And police chiefs and everyone were calling for his removal. And it got brought up into Parliament, and Parliament was adamant, let's remove this guy. And Liberals, members of Parliament, were calling for the invocation of the Section 33 to be placed on the law to reinstate the child pornography law. And now we're seeing exactly the same thing happen for almost identical reasons. And it's about
hold on.
control.
Let me jump in. First of all, Squirrel Nuts, thanks for restreaming the room. That helps. Or sharing the room. 1999, what was the government in power? Was the Liberal Chrétien government?
I'm not sure who was the prime minister, but Anne McLellan was the Minister of Justice at the time. It's a good question. I probably was. I should know, but I don't.
It should be Chrétien, because 2001, when September 11th happened, it was Chrétien.
Right.
So let's assume it was a Liberal government. This law that got struck down, how did it come into force? What was the intent of the law? What did it state?
Well, the law was trying to protect. Well, I mean, it was outlawing people possessing child abuse material. Child pornography is what the term that they used for it. And that was the intent of Parliament, was we want to send a message that this is wrong, and we want to protect the most vulnerable. This judge declared that unconstitutional. It had this outrage, and then the case mid-trial was sent up to the BC Court of Appeal. This is before the sentence was passed. It was appealed up to the BC Court of Appeal. BC Court of Appeal did their thing, and then sent it up to the Supreme Court of Canada, which did their thing and said, made some exemptions to the free expression exemption, and then sent it back to trial to Judge Shaw, who passed sentence on the man and passed a 3-month sentence. I think it was a suspended sentence or something like that at the time. And that was the end of that R versus Sharpe case. But what it did was, the whole point of it was to challenge Parliament. What would Parliament do? Would Parliament stand up and protect its legislation, or would they allow the judiciary to declare a law protecting the most vulnerable Canadians to be unconstitutional? And that was why they brought it to Parliament, was to check if Parliament would basically exercise their Section 99 powers to remove a judge. And when it came to it, Parliament absolutely caved. There was debates in Parliament for a full day, basically, and every MP, just as we're seeing right now, are out. Well, right now we're just seeing it on the Conservative side, but back in 1999, there was outrage from MPs and everyone across the board wanting this judge removed. The comments in Parliament were pretty phenomenal. It's like, and this is where I received a lot of my material that I ended up using, sending it to communicating with Trudeau in my case, because this was the same judge that had ended up ruling in my case and resulted in the Canadian Judicial Council claiming that judges could ignore the transcript and protect lawyers committing fraud on Canadians. So that's how it connects to me, which is basically they're saying that judges have absolute power over all evidence. So a judge can hear a case and make it appear any way that he wants, no matter what the evidence is. A judge can control the entire process, weigh all the evidence, and nobody can judge their judgment, basically, is what they're saying.
What do you think happened if you're saying that the MPs overwhelmingly wanted to sort of remove the judge and then they pulled a 180? Is it an application of responsibility where they're like, oh, well, let's not rock the boat? Or what's your sense?
Exactly. So what happened was they all made these grand, elegant statements about how they needed to protect children and how outrageous this was. And then the Minister of Justice, Anne McLellan, who is also the advisor to Justin Trudeau, who wrote the opinion about the Attorney General and the Minister of Justice being independent and having the dual powers, that after the SNC-Lavalin affair. So this issue connects everything throughout the Canadian legal and political system. It's about how the Attorney General and the judiciary are fighting with Parliament, fighting against Canadians, basically, because Parliament is the representatives of Canadians, right? And they're pushing back and saying, we don't want to be accountable. We don't want to have any limits to our discretion. And that's what this is all about.
No, I get it. It's like the growth of I don't know if you want to call it the government, the deep state, the bureaucracy. We're losing democratic control and oversight, and we're almost surrendering it.
Mm-hmm. So what happened in Parliament back in 1999, the Minister of Justice got up and said, we can't do this because it would be, judicial independence and all this kind of stuff. But Section 99 of the Constitution gives Parliament the duty to dismiss a judge for breaches of good behavior. And Parliament was pretty darn sure that this was not good behavior. The judge had declared their law unconstitutional, protecting the most vulnerable. So they had about as good a case as you could possibly have. But the Minister of Justice got up and said, let the legal system handle it and don't dismiss this judge. And they are regretting it to this day, because what happened after was that judge appeared in my case, and then I brought it forward and pushed it all the way through the legal system and said, this is the problem, is that you allowed this judge to stay on the bench, and you should have removed him back in 1999. And now I'm pushing it right the way back into Parliament and saying, now you're accountable. And that's why Parliament didn't want to touch it with a 10-foot pole. And that's why they prorogued Parliament, and everything happened was they did not want to get into, because Parliament basically doesn't want to judge judges. That's sort of the reality, is they're scared of it because it makes them accountable, and they want to push that accountability back onto the judges. So it's a very interesting, complicated issue. But so what they did was they offered up.
How does this tie into prorogue? You're talking about 2024.
Exactly. Well, because I was going through the legal system and I went into the politics, the political system with all of this evidence, is that Parliament failed back in 99 to remove Judge Shaw. Judge Shaw appeared in my case and ruled that judges can protect lawyers committing fraud. And then I pushed that up to the Canadian Judicial Council, which affirmed that judges can protect lawyers committing fraud, which is unconstitutional. And then I pushed that to the Minister of Justice. He failed to comply with the enforcement procedure of the Charter, which is unconstitutional act by the Attorney General. I pushed that through the legal system and asked for accountability of the Attorney General. They invoked the Emergencies Act. I challenged that in the federal court, presented the evidence of the Minister of Justice lying to Canadians and not removing a judge who had protected a judge committing fraud, protecting a judge committing fraud on Canadians. And then that I asked for that to be debated in Parliament, for Parliament to check the powers of the judiciary, that they claim that they can reject the transcript and all evidence that any Canadian, basically the Judicial Council is saying that we have no duty to judge what a judge does. They can make up any decision that they want, and that's fine. And all that
you're describing basically a runaway train. You're describing a runaway train.
Absolutely. It's a runaway train, and it comes all the way back to February 2nd, 1999. So that comes back to, why are they doing this now? And it's basically judiciary pushing back on Parliament. Parliament, for a couple of years after that, then started increasing the mandatory minimums on the possession of child pornography. In 2005, they went to 45-day minimums. And then in 2012, they increased it to 6-month mandatory minimums. And then in 2015, Parliament increased the mandatory minimums back up to 1 year. So that they're communicating back to the court saying, no, we want stiffer punishments on these offenses. And the other thing it does is that it acts as a prosecutorial check and a police check, right? If you're facing a year incarceration for possession, then police aren't going to charge an 18-year-old boy who looks at his phone and sees a picture of his girlfriend that she sent him on it and arrest him for possession of child pornography. It's never going to happen. And the police admitted that in this case, that would never happen. So what they did was the court created this foreseeable event, these reasonably foreseeable people, this 18-year-old boy and this how they do it. They said that we should eliminate Parliament's law because it's reasonably foreseeable that this could happen. But what the court did was completely remove the entire presumption of innocence and the entire legal system, and they declared the guy guilty, and it's not even a crime what they're alleging that this guy did, right? This imaginary, reasonably foreseeable person who happens to be an 18-year-old boy. It's not a crime what they're even alleging that he is doing, but they're also eliminating the entire trial process. They're presuming that he's guilty and that they're there facing the decision of whether they should incarcerate this guy for a year, and they're claiming that is is somehow unconstitutional.
Let me simplify this.
Yeah.
What you're saying is the court said, if we pass this law, minimum 1 year, hypothetically, there might be someone who's 18, his girlfriend's 17, and then, that would be cruel and unusual punishment. Is that what they're saying?
Exactly. but they're presuming that the boy's guilty right from the get-go.
Yeah.
So they destroyed the presumption of innocence completely. It's an astounding decision because they created a hypothetical that completely removed the presumption of innocence, completely removed the trial process, and stated that the boy knew. Well, they went even further. They knew that the boy knew that he was guilty of a crime without a trial. He's guilty of section 163.1 as a fact. No allegation, no proof required. He was guilty, and that's a reasonably foreseeable event to occur in the Canadian legal system, that he would go all the way through the legal system, prosecutors, police charging, someone laying charges on him, go through a trial, and no one would protect and do the right thing and protect the public interest in not charging this boy who's not even guilty of a crime. They just know that he's guilty. It's astounding.
So let me recap, and then I'll throw it back to you. First, Parliament tried to pass, let's say, stiffer laws, new laws for child pornography. The court strikes that down. Parliament, in desperation, they default to increasing the minimum sentencing for whatever laws there were on the books for child pornography dissemination, and the court strikes that down as well. So where are we now? What's next?
So basically, what the court has said is basically, you do not restrict our authority at all. You have no. We don't want you to control our discretion in sentencing, and we don't want you to control our discretion in weighing of evidence. And they use child pornography as their test case to do that through. So now in a way, it's like you could have police now lay charges, because now the minimum standard of this, could be a slap on the wrist, for instance, or whatever, a month in jail for someone for, maybe it encourages the police to go, oh, well, we should lay charges on this 18-year-old boy because the court knows that the boy knows that he's guilty. It's outrageous, right? It encourages people to prosecute and Crown to lay charges on crimes that are completely absurd. So
this reminds me of something someone said to me on one of our interviews. Said the law previously, it used to focus on the victim, getting justice for the victim, but now it's changed for how they're considering how it's going to impact the criminal, the accused, and that's not how it's supposed to be.
Yeah, and I think that's all as a result of basically institutional protection. So this decision is institutional protection. It's the court pushing back against Parliament, saying, don't check our authority. And every time the court does that, it's taking away rights from Canadians, because they're saying we want to have unlimited absolute power, which is completely contradictory to Canadians actually having rights in the legal system, right? Because they're saying we can do whatever we want. What you say doesn't matter. So it's obviously inverted the legal system, because it's taking a legal system centric, protect the institution rather than the public focus. And that's the problem, is that they're not focusing on the public interest. They're focusing on their institutional interest. They're just guarding the fort, and they're saying, this is our fort, don't come near it.
Yeah, no, I see where you're going with that. What's next? I know you had like a 10-step process.
I think we kind of jumped through it all pretty quickly, and I've kind of I've
So
kind
is
of
that
covered
lunch?
most of the points that I wanted to cover, but there's, it was kind of interesting yesterday looking at Twitter, and the conservatives knew this was coming down the pipe, and they knew that they were going to be talking about the notwithstanding clause because they had their arguments. They were all organized within hours of the decision coming out, and there was graphics already prepared. They were going to be presenting on their Twitter posts. So this was orchestrated in some ways. The other thing is that the decision itself, what happened was it was a single decision from a court in Quebec, and so that if the decision started off with 90 days for these guys, and he declared it the mandatory minimum unconstitutional, and so didn't apply to these two gentlemen. Then the attorney generals appealed that to the Quebec Court of Appeal, right? And so then the Court of Appeal there declared it that applied to all of Quebec, and then the attorney general then appealed that. And then the Court of Appeal also increased the guy's sentences to 1 year so that it did comply with the mandatory minimum anyhow. So basically saying, we're doing the right thing anyhow. But then the attorney generals appealed it to the Supreme Court, having got the decision that they want, like the verdict that they wanted, the 1 year. The reason they appealed it to the Supreme Court was to allow the judiciary to the Supreme Court, the federal judiciary, make that decision apply across Canada, right? You see how that process worked? It was unconstitutional for one case, then it was unconstitutional in the state of Quebec, then they declared the entire law across Canada unconstitutional, which made judges across Canada not have to apply mandatory minimums for sentencing on child pornography. They rewrote the law.
You're going to have to, Trevor, you're going to have to hold my hand and walk me through this because I'm absolutely clueless on this. I've been focusing on other things. This isn't the same 1999 case, right? This is a new one that was brought up before Quebec?
Yeah, exactly. Yeah. It really just blew up on the internet 2 days ago. I really didn't know that there was even this case coming through or too much about it, but it's not the same case as back in 1999. It was a new case. And for some reason, the attorney generals wanted this to happen. And they knew that the judiciary, well, my assumption is that I'm going to say it. My allegation is that the attorney generals are working with the judiciary to bring this happen, and they wanted this to happen.
When you say the attorney generals, you're talking about the provincial attorney general of Quebec and the federal attorney general?
Yeah.
And when you say the judiciary, you're talking both the judiciary within the province of Quebec, but also the Supreme Court of Canada justices.
Exactly.
That's pretty terrifying if they're working together. And the whole purpose of whatever the case was, someone got hit with having child pornography, and then they appealed the minimum sentence saying this is unconstitutional.
Yeah, exactly.
And
the stuff they had was pretty bad. The stuff they had was pretty bad, and the judge was really bad, like really bad, right? This was stuff that the judge should have, had at least the 1 year minimum, right? Should have followed Parliament's demands and treat this seriously. And he didn't, right? And then they took it all the way up to the Supreme Court of Canada, and that removed mandatory minimums for judges sentencing across Canada. So judges now don't have to follow Parliament's law.
Wait a minute. That's just for this one case, one law, right? Not or for all laws.
If in the possession of child pornography.
Okay.
Yeah. So not.
But
why they decide to do that is very. There's a lot more into it there that I'm still unpacking. But there's some massive mistakes in the decision. But there's also some very interesting implications about why they did it, and what it all means, and why the Conservatives were right up there with the Section 33. There's some political intrigue and some legal manipulations that are going on behind the scenes that I'm still delving into, because the implications are quite interesting.
What the decision, does it say that the minimum sentencing is unconstitutional, or does it say Parliament can pass minimum sentences? Just we as Supreme Court, as justices and judges, we don't have to listen to whatever they pass.
Yeah, basically they said we don't have to listen to what the Parliament says. We have to apply for mandatory minimums. We just want to have absolute discretion in our sentencing.
So just to be clear, like in 1999, they tried to pass a law outlawing child pornography, whatever. The law got struck down. But here, the law says this is the minimum sentence. They didn't strike. Did they strike the law down, or did they just say, "Nah, we're not going to listen to you"?
They declared the law, the mandatory minimum, to be unconstitutional.
Okay.
As cruel and unusual punishment. So they, in the case before them, it was absolutely not cruel and unusual punishment to sentence this person to a year or more for the crime that is in the books and protects the most vulnerable members of our society, children. And he didn't.
I'm going to ask you a tough question. You kind of hinted, or you said that you believe the attorney generals are working with the judges, the judiciary, to bring this about. They wanted to get rid of that minimum sentencing. I look at this, like, the country's in a very precarious position right now. It's almost on the verge of falling apart. We had the land title canceled. The economy's not going too well. You can go down the list. Are they doing this on purpose to piss the people off, why would you do this now?
Yeah, I don't really know the complete motive, and it's pretty hard to find out someone else's motive, right? Because it's theirs. But there's a couple of possibilities. Part of it is this is pushback, just normal interactions between powers that there's one power wants to push, and this is the separation of powers, supposedly, right? You got the people, Parliament, the executive, and the attorney generals and the judiciary. They're all power, and they're pushing back and forth at each other, going, "You don't do this, you don't do that." And that's what is going on. But the people don't really understand it because we're really not involved. But the people are starting to go, "Look, this is a real problem. You're pushing us out of having any rights in our legal system, and you're not protecting us." And that's there's a lot in there that we still need to figure out what's going on with why they're doing it.
It's really bad timing, and there's an election coming up. Apparently, we're inching towards an election. Everything is political. So I guess what's coming out of the Liberal Party? Do you know? Are they just are they taking the
silence? Absolute silence yesterday on the whole trial. The Conservatives were out in force, and then there was comments basically, and lots of lawyers talking about the case and discussing it, and it's generating conversation, and these are all good things. But so what might happen is the Conservatives go out and go rule of law and check the judges and Section 33 and parliamentary supremacy. And then when it comes down to it, they're not in power. So are they going to do it, or they're not? So it might just be kind of a little bit of theater. And then when it comes down to it, if they get into power, will they do anything about the situation? Probably not.
Yeah, I'd be inclined to agree. I think they just see the Section 33 as a nuclear option. Let's not do it. We might not win at the polls, and it's just for show.
So, I mean, the other thing is it could be divide and distraction kind of stuff. Right now what they have before them is they know that I'm at the UN challenging Canada's compliance with the International Covenant on Civil and Political Rights and claiming that Canada's failing to meet its international obligations in providing fair trials. So that is pretty heavy. And then Mark Carney's response to that was to appoint David Lametti as the UN ambassador. And I would assert that that is an attempt to influence that tribunal. So there's some pretty, and my evidence is that the Canadian legal and political system is protecting lawyers, judges protecting lawyers committing fraud. And that's a breach of fair trial rights. And so that is much more serious than what they have going on here. But they're using this to be a distraction. That's kind of one guess that I have.
It's interesting. If people want to know what Mr. Holsworth is talking about, we have done several other interviews together, and we've gone through your case in more detail and how you've taken it as far as you can go. You even took it to the United Nations, but it's just they're not listening, or they're trying to stall it.
Yeah, I had the best evidence that any Canadian could have about fraud and corruption in the Canadian legal system. And I stress tested the legal system and the political system to see if it lived up to the guarantee. And here, I'll just move this. I think I'm in the sun here. I can't really do it.
That's okay.
But yeah, so that's what they have going on. So, there's some pretty heavy issues. So, and so Parliament, they may be doing the same thing as what they did back in 99. Back in 99, they, on the same day as they're debating Judge Shaw, they brought up a judge who, as a lawyer, the judge's name was Flahif, I think. So they offered Parliament Flahif who was a lawyer. He kind of, I think he did drugs or something like that. There was some kind of allegation, and they got Parliament to dismiss that judge, but they protected Shaw. And they're doing the same thing basically now. And they're trying to do something manipulative.
It could also be that all of these Trudeau-appointed judges, they all have some. I mean, they don't have to be conspiring together in smoke-filled rooms, but they have some idea of where they want to take the country, and this might be a part of that, undermining the democratic process.
Yeah, there's a lot to unpack there. I spent yesterday kind of just trying to kind of understand the dynamics of the case and kind of touching in on what possible motives might be behind it, but I wanted to talk about that whole connection back to 1999, because it is a recurring theme, and Canadians need to be aware of what the implications are and why they're doing it and what it means.
So I guess this is going to be a short episode today. We covered it quick. If you, with your permission, I guess we'll work on those 10 points you gave me. I'm happy to add that to the post on X so people can kind of read through your Cliff Notes. Is that okay?
Yeah, sure. Yeah. So a lot of those issues, but I think we covered it pretty succinctly and to understand, and I really wanted to emphasize the importance of all that detail. But yeah, there's a lot of it. And then, people can look at my website, www.fundamentaljustice.com, to kind of get the full picture of what the issue is and kind of see what is the dynamics going on in the background there.
Well, Trevor, thanks for thanks for bringing me up to speed, because I haven't been following this. I'm more on the BC side with the property issues. So it's been helpful for me as well. Thank you.
Sure. No, thank you very much, Payman.
All right, Trevor, you enjoy the rest of your weekend.
Okay, you too. Thanks.